So our second case in which the Roberts Courts addresses questions of race occurs in the context of voting rights, a case called Bartlett versus Strickland. And in the Bartlett case, the question was whether minority voting rights could be protected against illegal vote dilution by a redistricting plan that would enhance the ability of a black district to elect a representative of its choice. And the question was whether the existence of racial bloc voting in the district, in the absence of a majority black district, justified drawing a district that would enhance the ability of blacks to elect their representatives. This occurs in the context of the Voting Rights Act. One of the provisions of the Voting Rights Act prohibits voting discrimination on the basis of race if, under a totality of the circumstances, blacks and other minorities are denied the right to vote. The Supreme Court has interpreted Section 2 of the Voting Rights Act to recognize a claim of vote dilution, and that is a claim that the votes of blacks do not count as effectively as the votes of whites in a particular voting environment. The General Assembly of North Carolina drew district lines for their assembly district, and they drew district lines across 2 counties in order to give a particular district 39% of the black vote. And the rationale for that line was that in those districts, whites voted as a bloc to prevent blacks from electing candidates of their choice. So that is an example of vote dilution. So the General Assembly thought that it had an obligation under the Voting Rights Act of 1965 to draw a district that would permit blacks to have a chance to elect a representative of their choice. Well, there was a lawsuit filed against the decision, and the North Carolina Supreme Court ruled that before the Assembly could draw a district that would enhance the votes of blacks in the district, that the district had to be at least 50% black. So despite the fact that there was strong evidence of white racial bloc voting in the district, the North Carolina Supreme Court said the drawing of that district was unlawful. And so the question presented in Bartlett is whether there is a remedy for racial bloc voting against the interests of minorities if those minorities are less than 50% of a district. And the argument is that if you are less than 50% of a district, you are in the same position as any other minority interest in your desire to form a coalition, and that it would be special treatment for that less than 50% majority to have the opportunity to have a district drawn. And so it comes down to, in this case, whether there is a remedy for white racial bloc voting if the black population is less than 50% in a district. And the ruling in Bartlett is that minority rights cannot be protected against illegal vote dilution by redistricting if minorities comprise less than 50% of the voting population in the district. And this decision then stands for the proposition that even if there is racial bloc voting that dilutes the effectiveness of minority votes, that there is no remedy for that racial bloc voting unless the minorities in that district are more than 50% of the population of the district. The third case involving race, and the second case involving voting rights is the Northwest Austin Municipal Utility District versus Holder. Holder is Eric Holder. And in this case, the Supreme Court had the opportunity to decide whether to strike down a very important part of the Voting Rights Act, Section 5, the pre-clearance requirements. I've already talked about one provision of the Voting Rights Act which prohibits racial discrimination in voting. Section 2 of the Voting Rights Act prohibits racial discrimination in voting if, under the totality of the circumstances, minorities are denied the vote. Section 5 of the Voting Rights Act identified a number of states in the United States where blacks had voted and minorities had voted in very low numbers prior to the enactment of the Voting Rights Act. There are many vehicles to suppress the black vote, and the Congress decided to enact a provision that would require special attention paid to any changes in voting qualifications and other matters concerning votes in those states where minorities had historically low numbers of participation due to voter suppression. So in Northwest Austin concerns that pre-clearance requirement under Section 5, and it requires states, counties, school districts, and in the case of Northwest Austin, utility districts to get approval from the Justice Department before making any change in qualifications to vote, the location of polling places, etc. And in an 8-1 decision, the court evaded the question whether the Voting Rights Act Section 5 was constitutional by construing the law to permit the district to seek a bailout or an exemption from the pre-clearance requirement. Although the court declined to address the question whether the Section 5 of the Voting Rights Act was constitutional, the opinion is replete with suggestions that if certain justices have the opportunity to decide whether the Voting Rights Act is constitutional, that they may be prepared to say that it is unconstitutional. So it's an important decision in that the Voting Rights Act survives, but it is also an important decision because it invites districts to seek an exemption from the provisions of the Voting Rights Act, which have played an enormous role in increasing the availability of the vote and the opportunity of minorities to elect representatives of their choice. So in Northwest Austin, the court avoids this ruling by permitting the exception from preclearance. The fourth case involves employment, and it's Ricci versus DeStefano. And in this case, we have the question whether an employer who rejects the results of an employment test because it fears that that test might lead to a lawsuit by minority test takers is engaged in illegal discrimination under Title VII of the Civil Rights Act. The facts here involve tests for promotion to lieutenant and captain. Applicants took the test, and the scoring revealed that there were racially disproportionate results. So let me digress a moment to talk about the law of Title VII of the Civil Rights Act of 1964. Under Title VII, there are two theories of illegal discrimination. One theory of illegal discrimination makes it illegal to make an intentional decision in employment on the basis of race. And we call that a disparate treatment theory of discrimination. Title VII also incorporates another theory of discrimination, and it grows out of a very important case decided early in the days of Title VII's enforcement, Griggs versus Duke Power. The second theory of discrimination under Title VII makes it illegal for an employer to use a qualification or a test that produces a disproportionate racially disproportionate effect on minority test takers. And the those tests and instruments that produce that disproportionate impact must be validated and must meet very stringent requirements for justification. And so after New Haven administered the test and then decided that the scoring revealed racially disproportionate results, it feared a lawsuit by the minority test takers against the city if it did implement the results of that test. And so New Haven refused to certify the list. The white firefighters on the list who would have been promoted to lieutenant and captain as a result of the test, if the test results had been used, sued. And their theory was that the decision to scrap the test was intentional racial discrimination against them. The white firefighters said that you are making a decision to eliminate the test because you believe that the test will produce a racially disproportionate effect and because you believe that you might be subjected to a lawsuit. Therefore, you are acting with race consciousness as you discard the results of the test. And so their argument then was that the decision to scrap that test was an act of racial disparate treatment, that is, intentional racial discrimination against them. And the Supreme Court takes this case. So the result in a 5-4 decision was that the court held that the city improperly discarded the examination. The court concluded that there was no strong basis in evidence that the examination was deficient, and that no basis to conclude that discarding the examination was necessary to avoid an illegal disparate impact. The court said that a statistical disparity was insufficient to constitute a strong basis in evidence of unlawful disparate impact, and that these exams had been extensively analyzed, that they were job-related and consistent with business necessity. And also no strong basis to conclude that they had a less discriminatory testing alternative that was equally valid. So if I can go back to that slide, some people say that the problem with the New Haven decision, that is not the decision of the Supreme Court, but the decision of the employment commissioners, was that they allowed test takers to take that new test rather than to find a way to assess the possible disproportionate racial impact before creating a list. But having given the test to the firefighters, they created a list and therefore created a situation in which there were arguably victims of their decision to scrap the test. And that perhaps had the city of New Haven found another way to assess the disproportionate impact of the test before creating the list, there might have been a different result. But nonetheless, that was not the course that they took, and so as a result, the court decided to strike down that test and strike down the decision to scrap the test and reverse the effort of the city of New Haven to further diversify their fire department.